Hi, everybody. My name is Zara. I'm an appellate attorney. I handle appeals in state, federal, and immigration courts. And in addition to appearing as an attorney of record for a client's appeal, I also often help other attorneys whose clients are taking an appeal, and I help them strategize and navigate the procedure. And also related to that, I help with substantive motions that come around the time that an attorney is thinking about an appeal for their client. And I want to talk about one of those motions today. And I want to answer a specific question, which is, when is it a good idea to make a motion to re-argue? In the New York State courts, as many of you know, there is a specific rule in the CPLR that allows you to make a motion to re-argue, either your own motion or your opposition to your adversary's motion, and try to get a different outcome from the judge. Something that I see a lot of attorneys doing is to make this kind of motion as a matter of course, without really thinking about it and not really assessing whether it's a good idea, whether it makes sense, whether it's in the best interest of the client. So I want to answer that question for you today. When is it appropriate? When is it a good idea to make a motion to re-argue? Well, I'll tell you. The answer is right in the statute. The basis for a motion to re-argue is that you have to point out that the judge in the order made either a mistake of fact or a mistake of law. And by pointing out that mistake, you ask the judge to reconsider their decision and to come out the other way. So you also have to show that the mistake of fact or the mistake of law affected the reasoning so much that the reasoning would be different if the court had gotten it right. So I know what you're thinking. But Zara, the judge ruled against me. Of course they made a mistake of fact or law. And I hear you. I know you're right. And if you were to ask me for help on your appeal, I would help you find the very best argument to bring that to the appellate division. But that kind of argument belongs in an appeal. You really should only make a motion to re-argue when there is actually a mistake of fact or law. I'm going to give you two examples so that you can get a sense of what I'm talking about. Both of them are from cases that I've worked on in the last couple of years. The first one had to do with a mistake of fact. And it was a personal injury case, and one of the claims was res ipsa loquitur, and you may or may not know that res ipsa loquitur applies when you can show that the defendant had exclusive control over the instrumentality, the thing that caused the accident. But you have to show that exclusivity of control. You have to show that no one else could have caused it by doing something to whatever it was that caused the injury. And in this case, it had to do with like a lifted rim on a field. And the field was under construction, and there was a fence around the field during the construction. The plaintiff was injured during the construction. And the court misunderstood the location of the fence. She understood that the place where the plaintiff had the accident was outside of the fence, when actually it was very clear from the record. It was all the witnesses agreed that the place where the accident happened was within this fence, which means that it was cordoned off from the public, which means that the defendant had exclusive control over it. This was a very good time to make a motion to re-argue, because we had to point out to the judge that she misunderstood one of the facts, and it happened to be the singular fact that the judge gave as the reason for denying this particular claim. So that's a place where it was absolutely appropriate to make a motion to re-argue. Now, another one is when the judge makes a mistake of law. And another case I was working on had to do with a contract, and it was a contract for the sale of an interest in the LLC, and there was a question about whether the contract, whether there was a contract, right? So the parties were disputing about whether they actually had a contract. It wasn't written, and one of the arguments was that there was no writing for it, and there's a UCC provision that deals with contracts for sales for sales of security, so interest in corporate forms. And the judge misunderstood that rule, and actually we're not sure where the judge got it from, but the judge went all the way back to the 90s and pulled up an old UCC rule that actually made a statute of frauds for a security contract, and cited that rule in the order denying the claim. And the problem was that the judge cited to a rule that was repealed in the 90s, in the late 90s. So not sure what happened there, but that was also a very good example of a time when it's appropriate to make a motion to re-argue because the judge made a mistake. Those are the kinds of mistakes you want to point out to the judge. You do not want to go and make a motion to re-argue and say, Judge, but you should have agreed with me the first time. I know you didn't agree with me in the motion or opposition, but you should now, because look at all my evidence and look at all my arguments. They're great. Those particular arguments you want to make to the appellate court, not in a motion to re-argue. The judge will just deny it. The reason this is important is because the judge will just deny it. So you've wasted your time and your client's money for something that is going to get denied. And by the way, does not extend your time to appeal, because a denial of a motion to re-argue is not appealable. Remember all of that. Keep in mind, the best time to make a motion to re-argue is when the judge has actually made a mistake of fact or law. Hope this was helpful. I have other short videos on my website, on my blog, that address other issues that you might find interesting as a practitioner. And you can go to my website to check it out. www.onpointexpertise.com is my website. /interest points, and you'll get to my blog. You'll find all the other videos and some other written blog posts with a bunch of good information for you. And until next time, enjoy.